Welcome to the Cumbria Chamber of Commerce podcast, your weekly update of business news and issues from around Cumbria. Find out how we support new business and help existing businesses to grow and flourish at cumbriachamber.co.uk. Now here's the Chamber's Business Engagement Manager, Julian Whittle, with this week's episode.
Hello, I'm here with Michael Bauer of Cumbria Employment Solicitors to discuss sexual harassment claims and how employers can avoid being on the wrong end of one. Michael, as individuals, we probably all have different ideas of what sort of behaviour constitutes sexual harassment. But what does the law say? Is there a hard and fast legal definition?
You're right, Julian. I'll often deal with clients who'll use the term harassment in a general sense, meaning being picked on or bullied or similar. But of course, yes, there is a technical legal definition. There are various types of harassment, sexual harassment being one of a number. And obviously today we'll focus on sexual harassment. There are two basic definitions of sexual harassment. The main one, which is most widely applicable, is essentially if a person engages in unwanted conduct of a sexual nature, and that conduct has the purpose or effect of either violating B's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment for that other person. There's another type that deals with unpleasant conduct if somebody's either given in to sexual harassment or has rejected somebody's advances. But again, in my experience, I see less of that than I do of the broad mainstream, if you like, sexual harassment.
Fair enough. So can you give examples of behaviour that might be construed as harassable sexual harassment?
Yeah, absolutely. It's essentially any unwanted verbal, non-verbal or physical conduct of a sexual nature can amount to sexual harassment. Right. It doesn't have to be directed at the claimant. It can be going on in the office generally, and that person is offended by it. So if their dignity is violated or that intimidating, hostile, etc. Environment is created, that is sufficient. So it will amount to touching, grabbing, sexual comments directed at the individual or being made generally within the workplace. Inquiries about someone's sex life is a one I've come across commonly. Even repeated requests to go out for a drink could amount to sexual harassment. Yeah. A one-off, the law is much more sensible than people think it is. It does accept that humour in the workplace and being attracted to colleagues is a part of human nature and human life. It's when it goes beyond what's accepted.
It becomes persistent.
It becomes unwanted and it creates that environment for the other person. You can have situations where there's been a workplace relationship, but it's ended and one party doesn't accept no for an answer and continues to persist. It can exclude sexual jokes, displaying pornographic photographs, as used to be the case behind most bars in the country and often in mechanics workshops. Places, certainly I've seen that sort of thing as a member of the public. Sending emails with material of a sexual nature. And a single remark can be harassment, but it won't always be harassment. There have been cases where blokes in an office downloading porn where the claimant wasn't shown the images and didn't complain about them was classed as harassment. And the key thing is there is a very thin line between banter and harassment, so employers should be beware.
So how prevalent an issue is this, do you think? I mean, is the number of claims increasing, and is the publicity around the Me Too movement having an impact?
I've got no doubt that Me Too has at the very least, raised awareness, encouraged challenges to behaviour of this sort that might have been accepted or been tolerated in the past or just seen as part of how the world works. And we've seen, some very powerful individuals who've got away with really quite shocking behaviour for years, it appears. The court cases haven't been determined yet. And I think that Me Too has raised awareness. It has made things more capable of being challenged. It's very difficult, if I'm honest. I did have a look at the statistics in advance of today to work out what precisely is going on, because a lot of the Me Too stuff has coincided with the removal of tribunal fees, which has caused an increase in claims anyway. So picking out the details is difficult. But I have had a look at a couple of surveys, and I'll just give you some, what I find to be, still quite depressing statistics. There's an ACAS survey where 35% of women say they've experienced sexual harassment at work. Another survey where 37% had been sexually harassed in the last 12 months. And in terms of reporting it and doing something about it, Only 24% agree that media coverage has improved their workplace culture. And only 36% of workers say they would be very likely to report workplace sexual harassment that they've witnessed, and only 38% if they experienced it personally. So there is clearly still a lot of work to do. I know from my professional experience, we act for employers and employees. There is still, I'm afraid, a lot of it about. And I've seen some fairly shocking cases over the course of my career, and even in the last 3 months.
There's often an assumption that it's always women that are the victims of sexual harassment and men are the perpetrators, but that's not always the case, is it?
No, it's not. And the rules, as you'd expect from the law, apply across the board. They're there to protect men and women from unwanted conduct of a sexual nature. So you could quite conceivably have a female boss sexually harassing a male boss. You could have two gay employees and sexual harassment between them. The sad truth of it, however, is after 20 years of practice, I haven't yet had one case where the complaint has been by a man against a woman sexually harassing him. Now, that's not to say it doesn't happen, because I have no doubt it does. It may even be that type of sexual harassment is even more difficult to report because of cultural issues than the other way around.
Yeah. Let's sort of get down to the nitty-gritty. Where does the responsibility of employers begin and end? I mean, to what extent is the employer liable for the behaviour of their employees?
There are two strands to it. So let's say in the workplace, an individual employee is sexually harassing another employee. Well, if the employee who's the victim of this wants to bring a claim, then they can bring a claim against that individual employee who is harassing them. But they can also, and they often do, bring a claim against the employer as well, because the employer is what's called vicariously liable for anything done by the employee in the course of their employment. So essentially, if the employee is doing it in the course of their employment, the employer is treated as if they are doing it themselves. Right. And in the course of the employment, so anything that's happening in the workplace, managers making decisions, behaving in a particular way in the workplace will almost certainly be covered. It gets more blurred when you get into office parties and things happening off the workplace, social gatherings outside normal working hours. Questions and factors to take into account on this is, did it happen on the employer's premises? Were they on duty? Was it a party where there were a wider range of guests, or was it quite a narrow set of guests who are connected to the employer? Did it take place immediately after work? Was it mainly colleagues that were present? So yes, employers can be held liable for acts that they didn't know about, didn't sanction, don't approve of. They cannot be held personally liable for criminal behaviour. There's also the sort of quid pro quo of that, is that because employers can be held liable for things they don't know about and don't approve of, there is what's called the reasonable steps defence, which I suspect we'll talk about in more detail in a bit, which basically allows an employer to defend a claim as long as they took all reasonable steps to prevent the employee from behaving as they did or from behaviour of that type arising.
But what if the perpetrator isn't an employee, but perhaps a customer or a supplier? So it's happening in the workplace. Does the employer have a liability there?
No, except in limited circumstances, which is, I'm afraid, a bit of a lawyer's answer. There were provisions previously for employers to be held liable for third-party harassment, as it's known. They were repealed, but in limited circumstances. So let's say there is a customer harassing, let's say it's a female customer harassing a male member of staff, and the male employee complains about it and the employer dismisses him. Don't be so silly, you should be flattered. If the employer's failure to act is motivated by the fact that that employee is a man, then that can be discriminatory in its own right. Yeah. And look, as I've said before, the protection is across the board. This is often more about abuse of power than it is about sex. And it can happen to both parties. It's difficult for men to report it. It's difficult for women to report it. What I would say is, again, for fear of repeating myself, is in my experience of 20 years, the tendency is that it is women on the receiving end of the bulk of this.
Now, where if a claim does arise, I mean, I can see multiple downsides for employers. I mean, I'm an ex-journalist, and the media, I can see, the media love reporting sexual harassment cases, so that there is a lot of potential for adverse publicity and reputational damage. Then there's the cost of defending a claim. Is it worth contesting a claim, and what are the potential penalties if you lose
as an employer?
Yeah.
I mean, it's a difficult decision, and each case, of course, depends upon its own facts. And often, feelings run very deep for obvious reasons on both sides. The employee has had the courage to come forwards, pursue matters, and they feel very strongly about it. The employer, if they don't believe or don't accept or decide to defend the claim, feel very strongly about the matter being untrue. So I think that entrenched view can sometimes cloud judgments. In my view, it is always sensible to talk. It is always sensible to explore with clients what resolution might look like. But, and I act for employers and employees, people take sometimes a line of principle on this, and those principles can come at a cost. I think the fact that there's the reasonable steps defence gives employers, if they've got themselves organised and run a tight ship prior to allegations being made, that may well be something that fuels a defence. They may accept the allegations have happened. They may accept that the employee has been wronged. They may even have sacked the employee who committed the alleged offences. But things may not be capable of resolution because the employer has the reasonable steps defence. In terms of compensation, potentially unlimited compensation is available. There are two key categories for compensation. The first is loss of earnings, which is intended to compensate the individual for financial loss they've suffered. So that may be if somebody's resigned because they couldn't tolerate the workplace, or they've been off sick because of the unpleasant consequences the treatment's had upon them, and they've lost money. That would apply. And then the second element of compensation is what's known as injury to feelings. And if I just go back to the definition, just briefly, the language used is quite striking. It uses things like violating dignity, an intimidating, hostile, degrading, humiliating or offensive environment. That is quite striking language for what is normally dry and dusty legislation. And the injury to feelings element of compensation is very much about that. People who have been subjected to long periods or even short, intense periods of harassment, it goes very deep into them and it can cause real upset and distress. And the injury to feelings compensation is intended to compensate them for the sense of upset, injustice, aggrievement that they feel because of that treatment. Difficult to quantify, but it's, again, to me, interesting that the law has that very common sense mindset, that it understands that people who've been on the wrong end of this sort of thing, it's affected them as human beings and they should be therefore compensated accordingly. So is it right to fight or settle? Each case turns on its own facts. The approach we take is always to explore all options, try and give the client practical advice as to what they want to do, but ultimately it's the client's decision. Sometimes claimants have unreasonable expectations. So you can't engage with them sensibly. It's always sensible to explore options, and the difficulty is that sometimes it's unavoidable and things do end up in court.
You mentioned the reasonable steps defence. So what measures should employers introduce to reduce the likelihood of a claim and to help their defence if a claim does arise?
Okay, there are two main elements to this. There's the sort of fairly paper-flavoured legally bits, and then there's the practical thing. The best way of stopping this happening is having the right culture in the workplace. The number of times where I've dealt with cases of this type where the employer client may say to me, but this isn't sexual harassment, it's just banter. This is just how we are. Well, one person's banter is another person's sexual harassment. Now, I am not a po-faced, boring lawyer who thinks the workplace should be just about working and that human beings won't have jokes with each other. They won't potentially be attracted to each other. There won't be off-colour remarks made. That is human nature. But there is a line to be drawn by managers, by senior management, by supervisors about what is acceptable and what's not. And managers have to stand apart a bit from their team and try and make clear-eyed decisions about what's acceptable and what's not, and deal with what's not acceptable, because it will creep. The more you let, particularly if there is somebody, a particular individual who is pushing at the limits, the more you don't set a firm boundary as to what's acceptable, the more that limit will move. And what you often find is you creep into a situation where somebody has potentially tolerated things for quite a long time, has seemed to be going along with it, but then enough is enough. And there have been cases where people have tolerated things for years. And the argument has been that because they've gone along with it, it can't have been unwanted. The sexual content of the workplace, or whatever it happens to be.
Yeah.
And there's a particular case where a set of quite young migrant workers, female workers, were given a really hard time by clearly a very unpleasant boss. And they tolerated it for a long time. And the court said they may have tolerated it, but in the same way that a battered wife tolerates domestic violence, that doesn't mean, because it's tolerated, doesn't mean to say it's wanted.
Yeah.
And so stamping out things, dealing with things firmly, fairly and promptly when they arise is key. Having good induction, setting a tone from day one when somebody comes in so that attention is drawn to the key policies that I'll come on to in a second. And the approach and the expectations when the workplace is highlighted. As I say, dealing with things if they arise, people have got a choice. They can either behave appropriately at work or they are going to face disciplinary proceedings and ultimately dismissal. As long as that is the tone, most people will fall into line. And if they don't fall into line, staff don't fall into line, they are going to end up being dismissed. Managers and senior management team set the example. They set the tone. There is no point in having policies if the boss at the top of the pile behaves as he pleases or as she pleases. In terms of a lot of that's common sense, Julian. A lot of that is about not allowing people to behave badly. The less common sense bit is the more legally bit that sort of establishes the all reasonable steps defence. So what should be in place there, as a minimum, is an equal opportunities policy, an anti-harassment and bullying policy, a disciplinary policy, a grievance policy, and I would also probably put a whistleblowing policy in place. So you have some paperwork that sets the expectations of the organisation. That's not enough in itself. Those then have to be embedded in the organisation. The mere existence of a policy is not enough. There must be practical steps to implement it. So induction, where people are told about it and what the expectation is, and making all employees aware of the policies and their implications. Training managers and supervisors in this stuff. It is difficult as a manager. You want good team spirit, you want high morale, you want people to be getting on with each other, but you've also got to be drawing a line where it needs to be. And that doesn't come naturally to everybody. Some people are good communicators. Some people are happy to be unpopular for a bit in order to do the right thing. Training managers in it is part of the expectation of the reasonable defences, all reasonable steps defence. And then taking steps to deal effectively with complaints, including disciplinary action if needed. Apart from that, sending a powerful message and deterring people from behaving badly, it's part of what's required. And look, these things are not hard to achieve. We do it week in, week out for client, reviewing this sort of thing and making sure they've got the right things in place and the right, if you want to put it in these terms, the boxes ticked, so that if something happens and they have no knowledge it's going on until they get a claim or a grievance or a complaint, they have the potential, if they take relatively straightforward steps, to be able to defend that successfully and not for the company to be held liable. The individual may still be liable, but they will not be. Right. It amazes me. I cannot think of a case yet where I've been acting for the employer where there have been allegations of harassment, where it has been, where all the boxes have been ticked on that reasonable defences aspect of it. Reasonable steps defence aspect of it. To me, it's a no-brainer. It's so easy to put yourself in, to protect you, and the law provides you with that protection as the quid pro quo for vicarious liability. Why wouldn't you make use of it?
Yep. I mean, you mentioned having an anti-harassment and bullying policy. What should that contain?
Essentially, it will set out the expectations of the organisation. I won't bore you with the ins and outs of what the wording will say, but it will say, essentially, this is what we expect. This is what examples of this type of conduct look like and what we don't allow. This is what you need to do if you have a problem. And it will talk about, if it's sensible, it will talk about informal resolution, because often if these things are dealt with early, they can be nipped in the bud before they escalate. 9 times out of 10, these problems end up at my door or at the tribe, and I used to be a tribunal judge at the tribunal's door, because opportunities to resolve a situation haven't been sensibly handled. So you'll talk about how you raise a complaint if you need to, and how it can be dealt with informally if appropriate. It should talk about victimization and the prohibition on somebody who has raised a complaint or acts as a witness in this sort of context from being treated negatively because they've engaged, they've raised a complaint or they've supported somebody who's bringing one. It's not rocket science. And it is, getting these things right is so powerful. It sets the rules for staff. It tells people what they need to do if there's a problem. It helps guide managers as to how to react if there's an issue. And it all, step by step, builds to the potential for having that all reasonable steps defence in place. So if the worst does happen, there'll be a sigh of relief because you've done what you need to do. It's not hard to do, but often it is, I'm afraid, lacking.
You mentioned earlier it's very important for employers to sort of set the tone with the workplace culture. What should an employer do then if they perceive that there is an issue with laddish behaviour perhaps, or inappropriate banter? Yeah,
and look, it is incredibly common. I think, again, covering to some extent what I've already said, the having the policies in place, making those policies known to staff, enforcing them as the need arises, training managers so they can manage this element of workplace life is all the key. Look, there have been cases where, as I said before, people have tolerated unacceptable situations at work for a long time. And the judges have said, look, there is a culture of sexual banter that exists potentially in a male-dominated industry and is actively condoned or participated in by a male manager. A female employee may feel compelled to join in with or not obviously take offence at such conduct or language because they find it demeaning, because they may be marginalised. That is building up the potential for a problem.
And I suppose as well, we're seeing a lot more of women entering what have been traditionally male domains like engineering. Yeah. So where this sort of environment might have been tolerated without a problem in the past, suddenly it becomes an issue.
Yeah, I think that's true. I also think that, times have moved on. There's that program on the television that says it was all right or it was acceptable in the 1970s, and you look at what was on the television, you look at how life was. It's fairly shocking. Times have moved on. Not everybody moves with the times. Some people do this, behave badly in this way innocently. They don't mean to. There are other people who do it. It's a form of bullying. It's an abuse of power. They just want what they want. And I think, it's human nature that you have people who bully. There is power on the employer's side to tackle that. And if they tackle it and they do it effectively and they have the measures in place, they will always come out on top.
What should an employer do then when a member of staff comes forward and complains that they are being subjected to sexual harassment?
Presuming it's a formal complaint, and there are grounds to take things further, so what the person is saying has apparent merit, then normally it'll end up in a disciplinary situation. So the first thing is to gather the details. Unpack that information from somebody. Find out the ins and outs of what it is they're saying. Investigate it thoroughly. It is in every kind of these process, in all of these types of process, the key to it is the investigation. And it is the bit I see regularly badly done. There are lots of times where employers, if they'd have just put a bit more energy and effort into the beginning part of this process or got help at an appropriate stage, they would have saved themselves a load of hassle. So investigate thoroughly. Follow up lines of inquiry. Be open-minded. You're not trying to prove that somebody's guilty or innocent. You're trying to get to the truth. So follow the evidence. And if you follow the evidence and you do that, not with an agenda, and you make the tough decisions if they have to be made, you will often save yourself a lot of hassle as an employer in the long run. So gather the details, investigate thoroughly. Ultimately, if there is a basis to it and there are witnesses, for instance, or CCTV, or even if sometimes, as is often the case, it's one person's word against another, which is not uncommon because people who harass people, they're stupid in one way, but they're not completely stupid. They're not necessarily going to do it in plain sight. If there's enough to proceed, then ultimately there'll be a need to convene a disciplinary hearing where the individual, the alleged harasser, is invited in writing to come to a meeting. The evidence is provided to them. There's a hearing at which they get to have their say and bring their own evidence. And ultimately, the employer has to make a decision as to whether they consider those allegations to be, inverted commas, proven. Now, you're not having in this context as an employer to prove beyond reasonable doubt that it has happened. All you've got to have is, having carried out a reasonable investigation, you've only got to have reasonable grounds to believe it's true. And that is sufficient to take action. If you've got somebody behaving badly in the workplace and they get away with it, all that does is embolden that individual to potentially cause more trouble in the workplace and more risk to the employer in terms of a claim. It also tells the other staff, they don't really care about us.
You can get
they
away
don't
with
take
this.
it seriously. And you end up with a Teflon manager who can behave as they want. And if they're that type of person, they will continue to push that boundary. So tackle it early, tackle it effectively, tackle it promptly and fairly, and that to some large extent. And if that means making difficult decisions and imposing a sanction, often this sort of behaviour will amount to gross misconduct and will lead to dismissal. To me, it is preferable to dismiss somebody who is behaving in this way, as long as the grounds are there to do it. If that's the right sanction, apply it, because it sends a powerful message. And really, do you want somebody like that in your workplace? Now, sometimes it's not that, and a final written warning will be appropriate. And in those circumstances, the person knows they're on a last warning. That sends a message too. But if you follow the evidence, make decisions that are based on that evidence, and take the broader picture, yes, it may cause disruption in the short term to have to sack a manager who is actually quite good at their job despite their harassing tendencies. Yeah. It might seem hassle in the short term, but I tell you what, that person, if they get away with it, will cause you, likely as not, bigger problems in the long term than the disruption of having to deal with them in the short term.
I mean, one last question, Michael. Is there a time limit on employees bringing these claims for sort of historic harassment, as it were?
Yeah, I mean, again, forgetting the criminal side of things, because you can get criminal issues arising out of this, which don't have the same limits in terms of the civil law. Essentially, you have 3 months minus 1 day to start the process, which these days is initiating the ACAS early conciliation process. So you have 3 months minus 1 day. So if it's a one-off event, a one-off act of harassment, it's 3 months from when that happened. If it's a campaign, a continuing series of events that essentially are ongoing, it's 3 months from the last of them. So what sometimes happens is employees raise their concerns. So something's been going on. They raise their concerns with the employer. The employer grinds into life and deals with it. The employee has to be careful that they don't run out of time in that 3 month period, because the employee, let's say the harassing employee is suspended or is dismissed. The employee then has so it stops. The employee then has 3 months from the last act to essentially start that claim running. Yeah. And look, I have seen it where employers will essentially try and push the process so the employee is out of time. So everybody has to be aware of the time limits, but employees particularly have to be aware of them.
Okay, thanks, Michael. Now, if this podcast has whetted your appetite, Michael is leading a half-day workshop for the Chamber called Safeguarding Against Sexual Harassment and Sexual Harassment Claims. And this takes place at Newton Reed, Penrith, on Tuesday, April the 30th. Places cost £50 plus VAT for Chamber members, or £95 for non-members. To register, go to the events section of our website. That's cumbriachamber.co.uk.
Thank you for listening to the Cumbria Chamber of Commerce podcast. You can find out more about how we're supporting Cumbrian businesses at cumbriachamber.co.uk and cumbriagrowthhub.co.uk. In the meantime, thank you very much for listening, and we'll have another episode for you next week.